I wanted to get in here and weigh in on this very, very important case and very, very important subject because today we have, or at least present in this case, we have a very, very important legal concept that is going to be playing a big role in it, and that is the idea of jury nullification. And that's what we're going to be talking about today. So, um, first off, I wanted to let's get into what is jury nullification first off, and then we'll talk about the case. We'll give you some background. So, concept here of jury nullification is jury nullification is when a jury acquits a defendant by refusing to apply the law or following their own sense of justice, even if the evidence suggests guilt. Jury nullification is not an officially sanctioned legal right, um, but it is a power that juries can exercise. Jurors are not instructed on the possibility of jury nullification, and judges may even discourage it. However, once in the jury room, jurors can make their decisions without outside influence. So it's the concept basically that the jurors can go back and, for reasons not related to the evidence in the courtroom, to make a social statement, they can find a defendant not guilty. So the case we're talking about here is Luigi Mangione, the individual who is accused of killing the CEO of United Healthcare. In this case, the allegations are that he gunned this man down in front of the Manhattan Hilton, or a Hilton, I believe it was in Manhattan. He guns him down, and then there's a manhunt, and they find this young man at a McDonald's in Altoona, Pennsylvania. What you're seeing behind me is when he was being brought out from his hearing, where he waived extradition, and he was then transported to New York. Now, there's a couple of interesting things that have happened in this case, which are very unique. One being, the feds have already jumped in on this, and he's actually been charged duly by the feds, and he's been charged by the state of New York. Now, we're going to get into exactly what those charges are because the state of New York has gone above and beyond this case. They haven't just charged him with the traditional unaliving charges, but they've charged him with with terrorism, basically, with the idea that he was trying to terrorize people with this killing. The feds have charged him with unaliving, except they've made it a death penalty eligible offense. Now, I'm going to explain to you why they did that and why you have, I believe, dual interest here from two sides. And it has all to do with the concept of jury nullification and the type of jurors they want to ensure are looking at this case. And they want to make sure this guy can't get out of prison, even if one side or one jurisdiction loses the case and the other then will get the opportunity to bring a case against him with a completely different jury. I'm going to explain all of that, but I want to talk about and I want to weigh in and respond to some of the media out there that's been talking about jury nullification. Set straight a couple of things, in my opinion, that need to be set straight in this case, because I think there's been some examples out here that I don't think are valid. It's just my opinion. I'm going to lay it out. We're going to watch some things, and I'm going to bring to you two cases, the two most notable cases, one of which no one's talking about. But there's another one that is one of the most notable cases of jury nullification out there, and it's really the should be the one that's talked about in this case because it's kind of got it was by in the healthcare realm when it was done. So, anyways, what we're going to do first is we're going to introduce a clip. Um, this is from a Law and Crime. It's courtesy of Law and Crime, and we're going to watch this clip from Law and Crime. It's their show. Um, it's their show, Crime Fix with Anjanette Levy, and they do an entire segment on this where they're going to be talking about um, they're going to be talking about um, jury nullification in this case. They're going to talk about cases, and we're going to kind of stop and start this. It's like a 7-minute clip, but we're going to watch this first, and then I'm going to take you to two cases that you can reference back and study if you want to see this jury nullification in action. One of them we don't have clips from inside the courtroom. The other I'll play some clips and show you what it actually looks like in a courtroom when a very skilled defense attorney is arguing jury nullification. So, and then we're going to read up on the status on where the Mangione case is, and then we'll leave it there. But I wanted to weigh in on this because this is something that I think is going to be a very interesting case to follow. Unfortunately, because of where it's happened at, there will be no cameras in the courtroom in either the state proceedings or the federal proceedings. Federal proceedings never have court cameras in the courtroom, and the state of New York just doesn't recognize it, doesn't allow it to happen. So, anyways, with that said, let's jump here to this first clip that I want to bring to you here.
What about my loved one who's missing? Or what about my crime that's gone unsolved? How come the government isn't spending those types of resources on those other cases?
And I think that that's a legitimate question. You know, I was doing some research and trying to go back in recent memory and looking at cases where jury nullification took place. And when you kind of Google it, you don't really find that many. However, there are people who think that the OJ Simpson case is a prime example of jury nullification because the jury in that case, there were jurors interviewed afterwards who said, yeah, I think.
All right, let me dispel something first of all. And again, maybe some of you will disagree with me in the comments here in regards to this, but I want to dispel this right away. OJ Simpson case was absolutely not jury nullification. You're going to hear the example given that this was done in response to the Rodney King case. The Rodney King case was an incident where a man was African American man was beaten by a band of LAPD police officers. They were all acquitted in state courts, and then they were taken to federal court, and a couple were convicted of civil rights crimes. Some were acquitted even there. This idea came from a documentary that came out a few years back. But if you understand the OJ case, if you actually have followed the OJ case was a verdict that had nothing to do with jury nullification. It had to do with the rejection of a bad case. It had to do with, if you looked at it, that there was actual police misconduct in that case where DNA was, and it came from several aspects. One, the handling of the DNA, which was the main evidence in that case. Two, it came from racist behavior from one police officer who made statements. And actually, what the thing that they leave out is the tapes that were played, or the snippet of the tapes that were played for the jury, is where this police officer admitted to planting evidence against black people, against a man. If there was a black man and a white woman driving in a vehicle, he said he would tear up their ID. That was played for the jury. And this is the same man where there were irregularities surrounding a glove that was found on OJ's property. Irregularities such as it was still wet hours later when it shouldn't have been. Irregularities such as pictures taken at times when his hand was taken and he was saying he was already at Rockingham, but yet it showed he had come back and possibly taken the picture, and his fingers pointing at a glove. There was irregularities such as a blue bag found over the gate in the neighbor's house that was predicted by an informant to the defense, who said, go look at the evidence collections. There's a stick that was found that matched branches from a plant from the crime scene at Bundy that could have been used to pick up the glove. This was more than jury nullification. This was a rejection of a case that was a rush to judgment and that had problems with it. And that O.J. Simpson was luckily able to afford a very, very competent, very, very good defense team who came in and analyzed the DNA evidence, who looked at the timeline. There were timeline issues. There was the inexplicable issue of why was there blood coming up the driveway, yet the allegations were he went around and jumped the fence and never went into that area of the driveway. There was the issue of Why was there why was there not blood all over his white carpets and his white walls? And there was nothing, yet he's supposedly coming back covered in blood. There was never an explanation given as to how he got rid of all the clothes that he would have absolutely had to have had on if he got back, or why there wasn't more than a few nanograms of blood in the Bronco. Ultimately, that was looked at, and that was not seen days after, and it wasn't seen until nearly 65 days after the crime. Those are the things that the jury heard about. Those are the things, not to mention a timeline that they absolutely could not get right, where there was a man, Robert Heister, who heard hey at 10:42, making a timeline that was nearly impossible for OJ to be back, being seen and talking to Alan Park. These were the problems. That's what you call reasonable doubt. That's why the jury rejected the case. It had nothing to do with jury nullification. So I want to get that out. This is what happens, though, when you have individuals that come on and they're talking heads and they're not really familiar with the case. They're just talking about the mainstream media's version of these cases. Now, you're going to hear he does bring up a case, which to me is the best case that you have for jury nullification out there. But he claims the OJ case is. But anyways, let's listen to the rest of this as we listen to this and play the rest of this.
That's a huge problem.
The Mark Furman aspect of it, the Marcia Clark aspect of it, the if the glove doesn't fit, you must acquit, all that jazz. So people look at that as maybe an example of jury nullification, but you don't really see it happen all that often. Also, another example was Jack Kevorkian. He was acquitted, and that was on camera as well, assisted suicide. So can you think of any other cases where it would be an example of jury nullification actually happening?
I think those are two of the best examples, because oftentimes, even when we have a shocking jury verdict, jurors don't come out and say, yeah, I think he did it, but I decided to completely disregard the law and the judge's instructions. Most of them don't do that. But I think OJ is probably the best example. And obviously one of the most famous cases in American history, because you had not necessarily a defendant who was really sympathetic, but I think people in Los Angeles were really upset at the Rodney King verdicts. I mean, the first not guilty, and even in the federal case, there were still some not guilties. Only a couple of the officers were convicted. I mean, that was shocking because it was caught on video. And I think more than that, you have Furman, you have the LAPD, just the horrible racist evidence that came out. They really wanted to punish law enforcement in that case. So even though they weren't a party necessarily, or because they were investigating the case, and I think the jurors were so fed up with the corruption and the racism and LAPD, and Rampart happened around that time as well. I mean, jurors wanted to send a message that, listen, like, we're not going to side with someone.
Okay, let's just, like I said, and again, this is what happens when you have somebody who really isn't really prepared for their questioning. They haven't done a whole depth of research, and they're going to try to make that case fit. Absolutely not. Like I mentioned before, the OJ Simpson verdict was a reaction to misconduct and not investigating a case, but it was because there were legitimate reasonable doubts in the case. And there are no jurors. I researched it. I looked it up. There are no jurors that say it's jury nullification, at least at the time. Now, since then, since they did this other documentary, they went back to a couple of jurors and suggested that to them, and they said, "Oh, yeah." But at the time, these jurors, they wrote books on it, and they said, listen, now they're aware of these cases, and those things factored into their belief that the LAPD was corrupt and the LAPD had problems, and it made them believe it was possible that they could frame OJ Simpson and that they could do the things the defense was suggesting. But it was not jury nullification. It was not such an incredible, crazy case that they just said, oh, we're going to let a guy get off for doing what he did in that case. That's just not the case. What it is they had legitimate, reasonable doubts that were raised by very good defense attorneys who tore apart a case that had legitimate issues. Anyways, with that said, I just wanted to, again, It bothers me much when I see people misstate the OJ Simpson case as jury nullification, because it just was not. That's just not the case. So let's keep listening here.
That we don't like. We're not going to side with LAPD. Jack Kevorkian, of course, assisted suicide. A lot of people had a lot of sympathy for him. They thought that here's someone who's helping people during the most dire time in their life. So they wanted to send a message that we did not think that this case should even have been prosecuted. So obviously, assisted suicide, there's people on both sides that have very strong feelings about it, but it's not.
So, Jack Kevorkian. Now, as I've said, that is a fantastic example. So, right here, I want to bring up the Jack Kevorkian case. So, I have some clips here for you. I think it's appropriate time to play. And if you're wondering, what does jury nullification look like in a case in a courtroom? His attorney was absolutely amazing, and he defended Jack Kevorkian several times. But this is the first case that they took to trial back in 1994. I have a clip from it, and I want you to listen, because this is going to be what I think. If we were able to see what's going on in that courtroom, we will only hear what the reporters tell us. But this is something that I think is going to be similar to what's going to be seen by these jurors who will be arguing the Mangione case, and I'll kind of get into that, how I think they might frame it. But there's going to be some similarities to what they're going to be arguing, although I think it's going to be a little bit more nuanced in the Mangione case, because I think what they're going to rely on is the motives, and they're going to play off of that, and they're going to let the state kind of make the nullification case, and then they're going to kind of say there's doubts, and they're going to let the jury kind of decide, in some cases where you have a masked assailant and things of that nature, and they would look at it and say, oh, that's definitely him. There's going to be doubt the way this is the way this is laid out. And Mangione was already saying things were, they planted the manifesto, they did this, they did that, they did all of this. And I think it's going to be a more nuanced jury nullification argument. But then again, maybe not. Maybe they're going to come in and they're going to do something similar to what you're going to see here in the Kevorkian case. So here it is, guys. Check it out.
This is now my closing argument. I won't talk again after I sit down. Mr. Kenny will come back up here and try to convince you again something that I can't believe is happening in 1994. And I would respectfully request that each and every one of you, at the conclusion of this, not so much for what you're going to do for Dr. Kevorkian in the jury room, but for every other person who lives within this state. We're not just talking about now what we're going to do for Dr. Kevorkian. We're talking about an attempt today to put kindness, to make kindness and compassion, to make mercy for your fellow human being a crime. And that if you render kindness and compassion to any living person in the state of Michigan who cries and begs for the kind of help that Thomas Hyde, you go to prison.
Judge, I'm going to object. The reference to prison.
We discussed this, Your Honor.
Okay, I thought that we had to straighten out. Remember the jury, the court make any decision about what happens, to a person and whether or not when they are found guilty. But the jury only decides that. So possible penalty should not affect your decision, but certainly an option is for a person, if convicted, to go to prison. Understand that I make that decision. Okay. All right.
Today, in 1994, in April, we will send compassionate doctors to prison for helping us relieve our pain and suffering. It can't be. It can't be. We've been here before, We've been here before. We were here in the 70s. We talk about the rights of women to control their own bodies. And we were here in the 60s when we talk about the rights of every people to be free and equal. And we were here in the 50s when everyone was a communist subversive. And we were here in the 40s when they went after the Catholics and the Jews and the Gypsies. And we were here in the 20s when they made the teaching of evolution a crime. And we were here in the 10s when they sent Margaret Sanger to prison for sending birth control information through the mail. And we're here again in the 90s. And we're here again with my esteemed defense counsel saying to you that Thomas Hyde should have been made as a matter of law to suffer the kind of death that everyone here testified he was going to suffer at the end. A death that we wouldn't wish upon our worst criminal. A death that only he was going to suffer, who had done nothing wrong. He who was going to gasp for his last breaths, and as Dr. Schwartz told you, all the meaning, the love, the existence, his control over his very life is destroyed at that when he says, why? Why don't I have the ability to decide for myself how much suffering I have to undergo before I meet my Maker? And Mr. Kenny says to you, I'm not trying to be dramatic, we end the right of all people to decide for ourselves and end the right of us when we are dying like Thomas Hyde was dying to look at somebody else in the eye and say, a competent medical doctor, and say, help me end my suffering. We end that. And we say to Thomas Hyde, we condemn you as a society to suffer a death that we wouldn't even impose upon our pets. What kind of people would we be? What kind of people are we that we would treat Thomas Hyde worse than our pets? Worse than a dog or a cat that was lying there begging, had no hope of survival. And we would say that was humane. And we would say to Thomas Hyde, you choke to death. Can't be.
And that, ladies and gentlemen, is a prime-time example of jury nullification at its best. Jeffrey Feiger was a fantastic attorney. I remember watching these on Court TV as a young man, as a young child. I think I was 12 at the time. I remember watching these. I remember watching they would come back, and Court TV used to do a series where they would replay or show trials in like an hour format. And I remember just being so inspired by this guy because I thought, what a fantastic orator. And of course, with my father being an attorney and having been around this, I've always thought, when you see great defense counsels giving passionate defenses of their clients, it's just inspirational. Now, let's watch. The next clip I'm going to show you is going to be a clip of
Kenny and Mr. Feiger. The jury, I have received a note. By the way, I should say for the record also, earlier today the jury sent a note saying we would like a copy of the assisted suicide law. That was about 11:55 at site bar. I informed Mr. Kenny and Mr. Feiger what I've done with that. I was just to make a copy of that with appropriate parts redacted, and to send in the 12 copies of that to the jury. And at 12:22, the jurors sent a note that they had reached a verdict. Before I have the verdict announced here, just to be sure, one way or the other, you all agree on a verdict here. Am I correct with that? Okay. The clerk would please take the verdict, please.
Madam Chairperson, would you please stand?
Yes, you said, pardon me? No, how did you said Madam Foreperson?
I meant to say foreperson.
Okay, all right, just go ahead and say foreperson. Okay, go ahead.
Please stand. What is your verdict as to the defendant, Dr. Jack Kevorkian, guilty or not guilty of suicide assisting?
We, the jury, find the defendant, Jack Kevorkian, not guilty of assisted suicide.
Okay, don't, please. Okay. Will you bring me that form, please? Okay. Now, I'm going to have the clerk do what we call polling the jury, okay? Essentially what that means that you will be asked individually regarding the verdict announced by your foreperson.
All right, so there you have it, guys. That is an example of what a jury verdict looks like when jury nullification is applied here. Like I said, he had actually 2 more verdicts that were not guilty. He was charged again and again and again by the state of Michigan. Eventually, they got him. Eventually, they convicted him because he kept breaking the law. And eventually, they got a jury that was not going to do this for him anymore. And he was convicted, and I believe his sentence, he actually ended up appealing, and he got pardoned or a commutation of his sentence, and eventually was released and agreed never to partake in those acts again. But it was an extremely controversial case. And as you heard there, the argument from his defense counsel was jury nullification. I mean, he was simply saying, ignore the law. The law doesn't make sense. It doesn't make sense from a sense of humanity. It doesn't make sense that we would allow our dogs to end their suffering, but human beings to not. And the state of Michigan doesn't have a law that allows it. The prosecution's decided to bring a case against him. You have the right as jurors to reject this case on the simple fact of a principled approach and to do the right thing and to say, look, I don't care that he broke the law. And that's what 12 jurors agreed to do. And that's what's going to happen, or at least that's what the attempt is going to be. Now, it's going to be a little bit of a different argument. The Mangione case, I think, is going to center around what this CEO's company is responsible for and what he's been responsible for, as saying the CEO is responsible for the decisions and actions and the policies set forth by its companies below it, that this guy was getting rich. This guy was making money. This guy was making his shareholders money off the blood of millions, and that this was done in self-defense of all those people who've had a claim declined or denied, delayed, deposed, whatever, where they've ended up in these situations where they've had to file lawsuits, or they've had a delayed claim, or they've had a denied claim, and death or suffering has resulted from it. And he's saying this was in defense of those people, to bring light to it, to bring light to this problem that I'm not a bad person. I'm not a killer. I killed a bad actor who was killing others. And if I didn't do this, millions and millions more would be killed. So free me and set me free, and set forth and start the conversation on how we can begin improving the healthcare industry and reforming the healthcare industry so that it is what it's supposed to be, about helping people get healthy and not about making profits off of people's misery and off of people's healthcare issues. And again, this resonates with lots of people. It resonates with me in a sense. And it's going to be a tough case when this gets to the jury. Now, I think, and we're getting into this a little bit deeper here in a moment, because I want to finish the clip from Crime Fix. This will resonate with some people, but when you have a death penalty jury, which is what will have to happen in the federal case, you're going to eliminate those people, because remember, the individuals who say, I cannot and won't put or give someone the death penalty, those individuals will be taken out of the jury pool. They will be disqualified based on that alone, which means you get a more prosecution-centered, a less likely jury to give to nullify this guy's action through jury nullification. On top of that, of course, they're going to have him at the Manhattan Detention Center or whatever, Metropolitan Detention Center, which is a prison, one of the worst jails in the world. It's deplorable conditions. It's one meant to make him suffer. It's one meant to make him consider taking a plea and working this out and saying, hey, you can get it. Go ahead and move on to the federal penitentiary system and get out of these deplorable conditions, as opposed to sticking around and fighting this for years and years and years. Because what's going to happen is the state court will more likely happen first, the state case. The federal case will happen second. and he'll remain in federal custody. And even if he should be granted bail in state court, the feds are going to deny him bond, and he'll still be sitting in those conditions. He'll be sitting in that detention center. He'll be suffering if he even makes it to trial for other reasons that we've seen become like Jeffrey Epstein and other defendants who have decided rather than sit in those conditions, they did things, or maybe there was other ways that things happen. But I believe the feds are involved right now because they want to keep his butt in jail, and they want to ensure that even if he beats the state case, even if jury nullification happens in that case, it'll be far harder on the death penalty side, getting a death penalty jury in there to have jury nullification happen, because you're going to eliminate a lot of the jurors that might be more willing to go down that path. Now, as you're going to hear discussed here, there's another concept here, which is shadow jurors, or jurors that are willing to lie to get on. Are you going to get 12 of those? Probably not. So you're going to get a hung jury, and you're going to get the opportunity to go back and do it again and again and again and break this guy down, break his family's finances down, and make them continuously have to go through trial after trial after trial, break his will. And that would be another strategy that they hope that they'll be able to do. Ultimately, in the end, getting a conviction, sending this guy away for the rest of his life, and putting him, again, remember, in federal time, he doesn't get to go to New York State Penitentiary. He's going to go to the Supermax. That's where they're going to put him, so that he can't have contact with the outside. He can't be a social media person. That's another reason why the feds got involved, because they want this guy to suffer, and they want to put a cap on it. They do not want this guy's message to get out. So, again, I think this is going to resonate beyond even federal juries. I don't think it's going to work, but this is literally, in my opinion, a case where you have the oppressed, and if you don't feel you're oppressed by the health insurance industry, then you're just mistaken, because you are. Okay, the costs of health insurance policies, the high deductibles, the tremendous amount of money that people have to put out and shell out in order to take care of costs. And believe you me, I've seen the other side. I help people who were crushed by the healthcare industry have to come get loans. I sat in court while I was going to court for my finance companies I worked for, and watched as the hospital would come in with 100 cases and 100 default judgments as they were going after people who had showed up with a medical problem and they had a bill, and these hospitals were going and getting judgments and garnishing wages and putting liens on their homes and just going after them. And all of this because those are the bills that the health insurance industry didn't pay. That's the stuff that the amounts of these high deductible policies didn't pay. And it's something that, again, they're profiteering off of things that are just going to happen. You're going to have health problems, and there's going to be a percentage of people that are going to have health problems. And we're going to get to see in this case huge debates about whether or not profiting should occur when people are in a position to not shop. One of the big factors that people never consider is when you go to the hospital, you don't get the opportunity, if you're in an emergency, to go shop and say, hey, do I want X, Y, or Z? Could I get this treatment cheaper over here? No, you're brought in. The hospital is forced to administer services for you because it's of an emergency in nature. They are going to save your life, and then they're going to leave you with this fat bill that has ruined your life financially. And that's just that. And and you have no say in it. You're unconscious. You're fighting for your life. And your family, of course, is making emotional decisions because they don't want to lose you. And you're not going to be able to say, hey, well, take me down here because this one's going to do it for, $10,000 less. No, you're going to get stuck. You're going to get a bill, and then you're going to get sued. And that's the nature of the healthcare industry today. What should be happening is there just should never be a chance to profit off someone in that case, in my opinion. And we should all be able to have an opportunity to get quality health insurance or quality health care, however form that should come, at an affordable price. And emergency should not be a time of profiting. That should be a time when everything is taken care of. And it's not a time that they're going to say, okay, this is when we run up your bill. while you're unconscious fighting for your life. To me, it's just tremendously contradictory. Anyways, let's listen to the rest of this little clip that I picked up, because they're going to get into some of this stuff. And now that you guys are familiar with the Kevorkian case, I think things will make a little bit more sense as you're listening. And you guys can evaluate, if you're familiar with the OJ case, which one you think is a better example of jury nullification based on what this gentleman tells you. And then we're going to talk about the other case of jury nullification that's out there. It's a case that was in the media. We'll get into it. Unfortunately, I don't have clips from the courtroom, but I do have an article I'll share with you, and then we'll wrap this thing up. Anyways, let's get back to it.
Really too dissimilar from health insurance. There are a lot of people that have very strong feelings about it, and that may come out during jury selection and more importantly, deliberations.
Jury nullification, probably, if you're a defense attorney and you're going for that, I assume it's all about picking the right jury. And it's going to come down to jury selection and really feeling out those jurors during voir dire.
Oh, no question. You want those stealth jurors, right? Jurors that are going to be on your side, but aren't going to tell the prosecution and the judge that they're on your side. So that's the type of juror that can hang a panel. That's the type of juror that could potentially cause them to acquit. Now, obviously, we know as prosecutors, I'm a former prosecutor, I'm going to take that perspective, we need to get 12 out of 12. So if we even get one of those types of jurors, those sympathetic jurors to Luigi Mangione on the panel, that's a huge problem, because it doesn't matter. If you're just looking at the evidence in the case, Anjanette, it's really overwhelming, right? You have the video. We've talked about that. His DNA on the water bottle near the scene. There's a fingerprint apparently on the burner phone. You have the ballistics that match as well. So you got fingerprint, DNA, ballistics, lots of forensic evidence. You have
a letter claiming, the manifesto claiming responsibility.
Yeah. So you got the motive there. It's him. So it's a very strong case in terms of the evidence. I don't know what Mangione is going to do, if he's going to push the case to trial, if he's going to take a plea. Obviously, New York doesn't have the death penalty anymore, hasn't had it for 20 years. So I don't know what motivation he'll have to take any type of plea. He might just roll the dice. But it's really a strong case in terms of the evidence that we have. And obviously, we cover a lot of murders on Law and Crime. Some of them are cold cases. Some of them are tough cases. This is an easy case in terms of the evidence. But in terms of the sympathy and the potential for jury nullification, not an easy case at all.
He's a smart guy. Okay. Valedictorian of his class, Ivy League school. He's got a bachelor's and a master's. He planned this whole thing out. I mean, he planned it out. He's smart. Okay. He's smart. I think he, if he indeed is the guy, he's accused at this point, he's charged. I think he wanted to get caught. I mean, he wrote the manifesto. He knew he was eventually going to get caught. Do you think he mapped this out in his mind? Like, do you think he wanted to go to prison and was willing to go to prison? Or do you think he's got some kind of plan?
Yeah, he is obviously very smart. I haven't seen someone as smart as him maybe since Ted Kaczynski, the Unabomber. And obviously, it appears that Mangione had read Kaczynski's manifesto. I think in some ways it's a little bit different, obviously, a different time. And we talked about the technology, right? Kaczynski was living off the grid, no electricity, no water. So he was able to kind of conduct these very smart letter bombings over the course of many years. But Mangione, obviously, he was smart. He certainly had a plan, right? He had the fake IDs, he got the burner phone, the escape path, and all that. He obviously knew where Thompson was going to be at that moment, right? He had enough sophistication to print a 3D gun. But ultimately, the question I have is, you're right. Why admit to it in writing when there's the possibility that you're going to get caught? There's a manhunt out for you. And why don't you leave the country, right? You have, all this cash, you have some foreign currency as well. Why are you hanging out in broad daylight at a McDonald's in Pennsylvania when you're the most wanted man in the United States? So maybe he did indeed want to get caught. Obviously, we don't know much about him. We saw some yelling while he was being transported to his first court proceeding. So maybe there's some mental health issues. Maybe he's trying to send some sort of message here, but I think we'll know a lot more about him in the coming. What about my love?
So that concludes the clip. Sorry about that. I didn't realize it was on loop, but a couple things there to talk about. One that I think is interesting in this case is that he touched on is the fact that Luigi Mangione knew so much about the movements of the CEO tells me that I think he had some help. I think there's other people that were involved close to this. That's just my take. So I don't know what his strategy will be, but I think that the strategy ultimately, to me, is probably more around, is going to be more based around um, him wanting to make this statement about the health insurance industry as a whole, about where it's at, about the problems that exist within it. That's what I think the point of this was. So I think if you ask me, I've thought about it. I've said to myself, will this be a more nuanced situation where they let the state talk about this? But I think the state's going to want to keep the motivation out as much as possible. Although with the state going with the terrorist idea, they're going to be framing all of that and saying he's trying to terrorize people by killing this health insurance. He's trying to terrorize CEOs. I mean, I couldn't think of a more unpopular position to take right now. He wants to terrorize CEOs, so good people of New York convict him. I mean, this is the same area. Remember, Mangione chose to do this in New York, the same jurisdiction that the jury leveled Donald Trump and hit him with the hundreds of millions of dollar suit. The same place where Trump was convicted by a jury. This is a jury that does not like, or this is an area that is not necessarily favorable to CEOs that are looked at as corrupt, money hungry, bloodthirsty. And that's the jury that's going to be looking at this in both cases, because there's going to be the Southern District of New York that's going to be taking on the federal case, and then there's going to be the Manhattan jury that's going to come in and be brought in for purposes of evaluating Mangione's case. Remember, Mangione comes from a background of wealth. So when he stands before this jury, it's going to be like, listen, I gave up all of this to take this stand because I became aware of how wrong the things were that this man's company was doing and that he was doing as a leader of this company, and all the blood that's on this man's hands. And the only way to stop this was to do what I did and hopefully make the health insurance industry. Is it the only way? No, of course not. Could there be an insanity defense that could come in? That could be a likely situation. But I don't think it is, because I think the purpose of this is for his attorney to go to court and make headlines arguing about the problems and the health care genocide that's going on in the healthcare industry, where people are being rejected, they're having claims rejected, they're dying as a result of health care, of healthcare decisions that are absolutely horrible. And people are dying, and it's true, right? And this guy is depending on that. And the question is going to be before the jury in this case is going to be like, do we, this man may have set in motion a discussion, although I think there's going to be a lot of money and power that is going to be put forth to try to deny that discussion from happening. But that's what he's hoping is going to happen, that this is going to make people talk. This is going to make people rise up and say no more. We need to reform this. But, I think it's a very audacious thought process. Will it happen? I don't know. Will he get off? Yes. Will it make any meaningful changes to the healthcare industry, the health insurance industry? Probably not, but it could, because people will be looking into this. People are going to look into his claims. He's going to have a very strong, powerful defense attorney who's going to be putting things out. And I think he's got a plan. I think he thinks he's going to get off. I think he thinks, obviously, that he's going to somehow be able to withstand the incarceration that's going to happen before. Or maybe he thought he was going to get bond. I don't know. If he did think he was going to somehow get bail that his family would be able to pay, I think he's sorely mistaken in this case. And I think he's going to suffer. And I think we're going to see if he can withstand that, because I think that the conditions he's living in now at the Metropolitan Detention Center are far different than what he was ever accustomed to when he was living a very posh, rich life in Maryland prior to all of this, prior to when he decided to go become a healthcare martyr. But we'll see what happens. Now, we're going to move on now and discuss the next case that we have the Dr. Kevorkian case. We already covered it. There's this case. This guy's name is Doug Darrell. And we're going to get into this case. And this had to do with marijuana charges through jury nullification in New Hampshire. We're going to read this article, react to it. So, a New Hampshire Rastafarian facing felony cultivation charges was declared not guilty on Friday because a jury believed that punishing him for the offense would be unjust. 59-year-old Doug Darrell was arrested in 2009 after a National Guard helicopter flying over his home found he was growing 15 plants in his backyard. According to WNTK at Darrell's trial, PRWEB reports jurors nullified the case against him. Jury nullification occurs when a jury concludes that a defendant is technically guilty but fails to convict the defendant on the grounds that the law in question is unjust. While jury nullification is legal, judges frequently do not inform juries of this power and may prohibit defense attorneys from doing so, according to the University of Missouri. At Darrell's trial, however, the jurors were fully informed of their nullification power, the Laconia Daily Sun reports. As per recommendation of defense Mark Sisti, Judge James O'Neill read aloud to the jury, even if you find that the state has proven each and every element of the offense charged beyond a reasonable doubt, you may still find the defendant not guilty if you have a conscientious feeling that a not guilty verdict would be a fair result in this case. Now, when I want to explain to you this is why this is such an important case. This case will be cited at what will be the pinnacle, the most important point if Mangione's defense is going to center around jury nullification. Because what this is a jury instruction that was actually given to this jury. And the jury responded in kind with a not guilty verdict. Now, does it mean that the judge will actually go forward and give this instruction? No, but I am certain that that Mangione's attorney will be aware of this case, because this will be a case that she should cite to the judge and say, I'm entitled to this instruction. It happened in New Hampshire. This judge did it, and that's called precedent. And since that judge did it, this other judge can do it if they want to, or they can become, they can go on the other side of this and decide not to do it, and then that can be a case cited by a prosecutor who doesn't want this read to the jury. But what an interesting situation happened here in this case, because Sisti argued that convicting Darrell would be unfair given that he was growing for personal, medical, and religious use. After deliberating for 6 hours, so the jury did not just go back and just do this, they actually deliberated for a while. The jury unanimously declared Darrell not guilty. Juror Kathleen Converse, self-described as a straight-laced little old lady, explained her reasoning in an interview with Free Talk Live. Mr. Darrell is a peaceful man, she said. He grows for his own personal, religious, and medicinal use. I knew that my community would be poorer rather than better off had he been convicted. Prior to trial, Darrell turned down several plea deals, including one that included no jail time or fine, Reason.com reports. Sisti said his client insisted on a jury trial because Darrell didn't think he was guilty of anything, and that is a sacrament in his religion. Informing jurors of their nullification rights will likely become the norm soon in New Hampshire. In June, Governor John Lynch signed HB 146, a bill that explicitly allows defense attorneys to tell jurors about jury nullification. So this is going on in New Hampshire. New Hampshire is quite a progressive area. But how interesting is that it is now codified in the law that jury nullification is something that the jury can be instructed upon. And this is something that I'm sure his attorneys, Mangione's attorneys, will rely on the law and the cases that instruction is given to say, we want that instruction given to this jury, because it's going to be, if Mangione's attorneys can get that instruction, it's a game changer. Now, you rest assured that the state of New York is going to fight against it. Rest assured that the federal prosecutors will fight against it. But imagine, I think every single jury instruction should include this. And I'm going to read this again. This is extremely powerful. Even if you find that the state has proven each and every element of the offense charged beyond a reasonable doubt, you may still find the defendant not guilty if you have a conscientious feeling that a not guilty verdict would be a fair result in this case. That should be read to every single juror because it is an absolute right of every juror to do that. And many jurors do not understand that. Many jurors would never go do that. Imagine if this was applied in a case like Chloe Driver. Imagine if this was applied in a case like the Ferris case, where they just said to themselves, where you had some people on that jury that said, hey, I think she's guilty. But, I'm not convinced beyond a reasonable doubt, or maybe you are, and you say to yourself, is this the right verdict? Knowing that the state has chosen to not charge other people, or if you think or suspect other people, could help jurors to get over that hump and say, wait a minute, we don't just have to have reasonable doubt here. If we feel the correct result to send this case back to the state and say, you know what, we don't like it. We don't like it. We don't think this person would ever do it again. Imagine the domestic violence cases that are out there. Imagine the abused women cases. If that was given, it would give an additional argument to the jury when many prosecutors lead the jury to believe that they don't have a right to not follow the law if they're looking at this. If they're saying, this person was given this set of circumstances, and I think they did this one time only, and I'm going to let them free. It would add whole other elements. And it's a right that every juror has. And whether it's given or not, the jury can still do it. It's just whether or not states have the decision on whether or not it can be argued to the jury and whether or not, and every defense attorney should let the jury know that. Say, listen, from outside, even if you get to the end of this case, even if you feel the state did it, it's still your right as a juror in this state, in this case, right now. It is the ultimate act. It is the ultimate power a jury has that you can acquit my defendant, for any reason you like. Even if you feel the state met every element of the case, but you just don't think they deserve to be convicted. You can do it. It's power you have. And that, ladies and gentlemen, is going to be what they are going to rely on in this case, I believe. And I think they're going to be making the strong argument about the blood on this man's hands, about what Mangione was trying to do and is trying to do and is going to try to do with this. And the idea that a conviction of Mangione is essentially an abandonment of all these people that have been wronged by the healthcare industry. That's the framing I think is going to come in this case. Now, again, you can debate whether you think that's right or you think that's wrong or you think they should do that or you think that's a legitimate argument or not. But that's where they're coming with this. And again, instead of talking about the OJ case as one of the best examples, why did Law and Crime not have their man prepared? Why did Anjanette Levy did not do their research? And I found this in no time and talk about this case and talk about what's going on in New Hampshire. She said, oh, it doesn't happen at all. New Hampshire has now codified it, signed into law by the governor, and they weren't talking about it. Why are they not talking about this? Why is this not being talked about all over the news? Why is jury nullification, if it's something that one state has seen fit as to something that should be disclosed to every juror who's evaluating a case, that's significant because that's going to be, I believe, going to be a debate that will happen in that courtroom on whether or not the jury should see an instruction like that. And that judge can give them that instruction because it's happening in another state. There's precedent for it. So we'll see what happens. But finally, I want to give you guys an update on where this case stands. So give me a moment here. Quick moment. We're going to switch articles. So give me just a quick moment. Got to switch up the articles here, and then we will end this thing, and we'll just kind of close this thing out. Let me there we go. So here we go, guys. So this is Mangione charged with an act of and United Healthcare CEO killing. A grand jury indicted Luigi Mangione, the man suspected of shooting Brian Thompson on an additional terrorism charge. I'll say it. What the heck? I don't know. I'll probably get flagged, but who knows? Luigi Mangione, the 26-year-old accused of fatally shooting United Healthcare CEO Brian Thompson in New York earlier this month, has been charged with unaliving as an act of. A grand jury indicted Mangione with the additional charge on Tuesday, according to New York prosecutors who have already charged him with the unaliving in the December 4th killing. This was a frightening, well-planned, targeted blank that was intended to cause shock and attention and intimidation, Manhattan District Attorney Alvin Bragg said at the news conference. It occurred in one of the most bustling parts of our city, threatened the safety of local residents and tourists alike, commuters and business people just starting out their day, he added. I think this was a mistake for him to charge. I agree with this, and that was actually discussed in another video that I saw on Law and Crime that they did. I agree. I think this was a complete ridiculous move by one of the most ridiculous DAs out there, Alvin Bragg, who seems to overcharge, lose cases, and mess up cases. Remember, this is the guy that charged Daniel Penny in that case and overcharged him and then lost the entire case. Mangione's defense lawyer in New York, Karen Friedman Agnafilo, sorry, I think it's how it's pronounced, did not immediately comment on the new charge. Under New York law, a blank charge can be brought when an alleged crime is intended to intimidate or coerce a civilian population, influence the policies of a unit of government by intimidation or coercion, and affect the conduct of a unit of government by assassination or kidnapping. Thompson, 50, was shot dead as he walked to a Manhattan hotel where United Healthcare, one of the largest health insurance companies in the United States, was holding an investor conference. So it's like, here's the thing that's crazy about this. He's going to have to make an argument to the jury that basically goes to the motive and makes the jury nullification argument. Because the motive for the jury nullification argument, okay, is going to be what's going to be the basis for this charge, which is what I saw the argument being, where they said this guy is incredibly stupid with the way he's prosecuting this case. But this is just how prosecutors act a lot of times. They overcharge. I think he's hoping that maybe he'll be able to use that as a negotiating tactic. I don't know. But listen, if this guy wants to go to trial and his purpose, he didn't do this because he, without the idea of wanting to to move something for a social movement, right? And the social movement is he wants to bring attention to the horrors of the healthcare industry. And this prosecutor is going to position himself against that and defend this. He's going to have to defend the healthcare industry. And that's what Mangione is setting up here. And it's actually genius. And this young man was very, very smart. And this prosecutor just fell right in that trap. Arrested on a tip. After a lengthy manhunt, Mangione was arrested on December 9th in Pennsylvania following a tip from a McDonald's employee. Authorities have a 3D printed gun, a suppressor, and several fake IDs, including one believed to be used by the attacker to check into a hostel in New York before the shooting. Were recovered when Mangione was arrested. Before entering court last week in shackles, Mangione gave a partly unintelligible message to reporters in which he could be heard referring to an insult to the intelligence of the American people. At the brief hearing, his defense lawyer, Thomas Dickey, told the court that Mangione would contest extradition in New York, requesting a hearing on the issue. He remains in custody in Pennsylvania without bail. While in court, Mangione wore an orange jumpsuit. Okay, so this was not obviously updated to the current status where he has now been transported to New York. So while in court, Mangione wore an orange jumpsuit, alternating between staring forward, looking at papers, and looking back at the gallery. He was quieted at one point by his attorneys when he attempted to speak. The brazen nature of the killing and apparent motive garnered national intrigue, even while condemning the violence. Many experts, doctors, and U.S. citizens said it was emblematic of the undercurrent of anger in the country towards the healthcare industry, where high costs leave many patients vulnerable to the will of insurers. Bullet casings found at the scene of the killing bore the words deny, defend, and depose, appearing to reference a phrase used by critics to describe how healthcare insurers avoid claim payouts. The gunman fled via electric bike to Central Park and later boarded a bus out of the city. Parasitic. In the days since the attack, many have taken to social media to share accounts of insurance companies denying claims. The law enforcement memo, which was based on Mangione's writings, some of which were recovered at the time of his arrest, said that Mangione was likely motivated by what he described as parasitic health insurance companies and an overall disdain for corporate greed. According to the memo, Mangione had written that the U.S. has the most expensive healthcare system in the world and that profits of major corporations continue to rise while our life expectancy does not. Thompson, who grew up on a farm in small-town Iowa, was trained as an accountant. He was a married father of 2 high schoolers. He had worked at the giant United Health Group for 20 years and became CEO of its insurance arm in 2021. Mangione comes from an influential family in Baltimore and was the valedictorian at an elite Baltimore prep school. He went on to earn undergraduate and graduate degrees in computer science in 2020 from the University of Pennsylvania, a prestigious Ivy League school. Known as affable and intelligent, some friends have said in interviews with U.S. media that Mangione's demeanor changed after recent surgery on his spine. Our family is shocked and devastated by Luigi's arrest, Mangione's family said in a statement posted on social media late Monday by his cousin, Delaware State Legislator Nino Mangione. We offer our prayers to the family of Brian Thompson, and we ask people to pray for all involved. Wow. So there it is. So that, folks, is the article there. That's the latest on the case, except for obviously that wasn't updated, but that's the evidence against him. That's where it stands. He's now been transferred. He waived extradition. So to update you since that article and what you're seeing behind me, he waived extradition, and then he was transported to New York City, where he's now being held in the Metropolitan Detention Center, and that's where he's at. So that's where we stand today. And at this point, he has not appeared. He's actually not appeared to answer the state charges. He has not appeared to answer the state charges, and he is. I don't even know. I think he appeared for the federal charges, but he has not yet appeared for the state charges. So that's going to be coming up probably sometime this coming week. He'll make an appearance. And of course, that's going to be a tremendous media event. The problem is, as we've seen with the Diddy case and we saw with the Daniel Penny case, there isn't going to be cameras in the courtroom. They don't allow cameras in New York, courtroom in New York. They don't allow cameras in the federal courtroom. So we're not going to see this. So although he picked a favorable area to do this crime in, as far as a jury that might have problems with CEOs and things of that nature, he certainly did not pick a jurisdiction where he would be able to have his case broadcast and he'd be able to have this, like the Kevorkian case, where you get to see his defense attorney make a passionate argument against the healthcare industry, because that's what he's going to do. That's what he's going to do. That's what the argument's going to be. And as you've seen, some judges will limit it, but there's going to be a fierce fight. That's going to be that they're going to be able to get that instruction into the jury that you heard that is given now to every jury, or can be given to every jury. Actually, I guess the law is that it will be given to every jury in New Hampshire, and they're going to argue that should be given to this jury. They're going to ask for it. That the jury, if they believe that there's some greater cause or reason beyond, even if the state proves every charge, if you want to let this man off because you see that he did this for a bigger and greater cause than just, hey, I'm going to go kill somebody, and I want to bring attention to the atrocities of the healthcare industry and the health insurance industry, acquit this man. And that's what they're going to argue. That's what they're going to ask. And of course, there's going to also be the backdrop of, do you think, could it have been someone else? Could do they have enough evidence beyond a reasonable doubt to say that was him? Because they still got at the end of the day to prove that. But they're going to say, listen, even if you're left with that, even if you believe it, he didn't do this. He didn't do this because he wanted to just go out and off somebody. He did this because he believes there's a greater reason, a greater purpose out there that he wants to bring attention to, because he says, hey, there's all these people being killed, being destroyed by the healthcare industry, that are having their claims denied and they're suffering, that are dying, their families that now don't have family members. And this individual, this CEO, was a leader of one of the biggest company in the country who's responsible for this. And the question will be before the jury. What statement do you make? Because those 12 jurors will be able to speak to the country. They will be able to make a statement louder than any politician can that will force the discussion. And if he were to walk out of that courtroom, and then if he does it again in the federal court, and he actually walks on this, he will end up becoming an activist like nobody else could for the healthcare industry. That's what I think he thinks. That's what he's going to ask the people to do. And that's what he's going to ask for people in that jury. And many people will be closer to relating to this than you think, that will have had people close to them, if not themselves, affected. I know I have. I know my son right now. We went through it this year with the healthcare. We had a switch in healthcare, and we've gotten massively large bills. We're fighting with the companies on it. Luckily, we have multiple coverages for him, but he's a diabetic. And if we would have only had my wife's coverage and not the secondary coverages that we have access to, we were looking at massive bills in order to provide him with what is required for him to live, to be able to get his insulin, to be able to have his blood sugars monitored, for him to have a little bit more of a normal life. And inexplicably, we were just told that this new insurance company has a different policy. They've changed what they're considering to be durable medical equipment for 2024. So I can relate to the suffering, because it's my son in there, right? Who now we have to make decisions. We have to decide. Maybe he doesn't get that anymore. His body, his ability to, the impact it will have on him when we're managing things manually versus having the technology to manage it. And the difference here is just because some healthcare company decided to change something and decided to make a change, and now we're out. And they just did it for profit because they want to profiteer off of people's health problems. And that's going to be the question before this jury. That's the question that we all have to look at when we evaluate this case. Should he have done what he did? Probably not. I mean, could there have been different ways of doing it? Yes, of course. But I think he did what he thought was the only way to try to bring attention to these issues. And that'll be a question that 12 jurors are going to have to answer. 12 jurors in New York State Court and 12 jurors in a New York Federal Court are going to have to answer these questions. And it's going to be a tough one. And you're going to answer the question in the comments. If you watch this video, if you've watched it to the end, if you become completely informed, do you believe, I want you to answer several questions if you made it this far. Do you believe a jury nullification instruction should be included with all jury instructions nationwide? Should there be a movement to include it? Should it be? 2, do you agree with New Hampshire including it and requiring it to be included with all jury instructions? And 3, do you believe jury nullification should apply here? And should the jury get that instruction in both federal and state cases here and be allowed to consider that as part of their deliberation process? Even if they feel the state has proven each and every element of this case, does the social aspect, does the reasoning of why he did this, does the greater cause outweigh the death of this man? And I don't think that's one that I would want to have to sit on a jury for, because it's tough. Because while on one side you have a guy whose family loves him, whose children love him, who shouldn't have had his life taken in this way. And it's just, that's a tragedy. On the other side, you have the idea here that this man's decisions cost millions and millions of people and families, loved ones, and cause unimaginable suffering across the country at times based on the decision to deny health claims, to change things. And again, as someone who's experienced that through my son's battle with diabetes, I can understand why people would have strong feelings here. And yet this individual walks in and we say, oh, is he innocent? Is he innocent? Or was this somebody who was in the process of perpetrating acts of violence through his company's policies that he was permitting, that he was signing off on? And was this the ultimate act of self-defense against the man who was greenlighting healthcare atrocities actively every day? You let me know in the comments. What do you think? Where do you think it stands? What do you think should stand? And how should this be handled? With that said, everybody, we're going to end this video right now. We're going to leave it at that. In the meantime, guys, until we talk again, let justice prevail, and I'll talk to you soon.
Luigi stood with eyes ablaze, a fire burning in his gaze, a courtroom silent all around, his story shaking every sound. A killer they proclaimed he'd be, but justice lies in what you see. A healthcare world so cold and bleak, he aimed to give the silent speak. Jury nullification rises bold, the truth in shadows now retold. For Luigi fought the darkest fight against the greed that owns the night. The CEO, his crimes unseen, built empires on the sick and mean. Profits stacked on helpless cries, Luigi's act brought light to lies. The killer they proclaimed he'd be, but justice lies in what you see. A healthcare world so cold and bleak, he aimed to give the silent speak. Jury nullification rises bold, the truth in shadows now retold. For Luigi fought the darkest fight against the greed that owns the night. The CEO, his crimes unseen, built empires on the sick and mean. Profits stacked on helpless cries, Luigi's act brought light to lies. Insurance games that steal your breath, Luigi challenged fate and death. A gavel falls but hearts might sway to free a man and clear the way. Jury nullification rises bold, the truth in shadows now retold. For Luigi fought the darkest fight against the greed that owns the night. That owns the night. Against the greed that owns the night.